so they obviously couldn't regulate all of them. So what they wanted to do is to bring in a lot of changes. So one of the first changes they brought in is to say they will have things like a core investment company, where they said if you are fundamentally a holding company investing in your own money, we don't want to regulate you. You can, you have limited powers to do what you're doing, but we don't want to regulate you. The second, I think, big movement which has come is pursuant to a report which is by, an ex-deputy governor of RBI called Usha Thorat. So Usha Thorat committee made some, recommendations, and and it's sort of very recent. I think as recent as earlier this month, that the RBI has actually, after about 3 years of the committee report coming in, the RBI actually came out with the guidelines. And the guidelines, if one reads, you will see that there is a huge convergence between banks. So, for example, you're looking at now saying that you have to have provisioning for your loans, which is higher. You have to have higher capital. If you have assets and capital worth more than 500 crores, you will be called what is called a systemically important financial institution, and therefore there will be a lot of prudential regulations which RBI will come in. And there, RBI really is fundamentally moving from a rule-based regulation to what a lot of developing countries have, to a principle-based regulation. So they'll come up and give you a lot of things which they feel that are prudentially required to regulate you. So those are some of the sort of trends which are there from the NBFC side. Of course, we were discussing, just before the panel started, that there are certain things. I mean, since I represent an NBFC, I can, say that one of the cribs which we have is that while, there is a move to, bring in convergence and a level playing field between banks and NBFCs, but yet there are certain powers and privileges which banks enjoy, and two of them being DRT and access to a special tribunal, which we will talk about later in the hour. And the other is the do-it-yourself regulation, which is called the SARFACI Act, which allows you to enforce your securities without intervention of courts. So both of these NBFCs have been not been given access to, and there is a constant effort to try and do advocacy to try and bring that into the fold and have NBFCs included. But we hope someday that's going to happen. So that's sort of from the NBFC perspective. The other, before I sort of get Mr. Gopalakrishnan to talk about his thoughts about, is that the other big thing which perhaps all of you all would be aware is that there is also this regulation, sort of report, which is, I think, very, very, very fundamental, called the Financial Sector Legislative Reforms. This is something which I think is a very important piece of legislation when it comes to banking and finance, because directionally this piece of work is telling us where our financial laws are going to go. It is talking about, it's basically saying that the government had formed a committee, and it's a very high-powered committee with Justice Sri Krishna to head the committee, and that committee looked at and said that there were about 60 laws which are sort of relevant insofar as banking and finance is concerned. Plus, there are regulations, rules, notifications, etc. Just eminently complicated, which lawyers don't mind, because for everything you do, you got to go to lawyers and get opinions and get that passed. But it wasn't very, very good for business. So therefore, the government said in a very progressive move that we want to you to look at all the regulations which are there. And there were some very, very, sort of drastic suggestions, if I may call it, which have been brought up. Things like having a unified regulator, not having an RBI, a SEBI, and an IRDA, and all of that, and have one unified regulator, or maybe two unified regulators, one for RBI for banking, and one for everything else. And similarly, it talked about, we will talk a little bit perhaps about consumer protection. It also talked about in consumer protection where it's going. It's really looked at moving from an age-old principle of caveat emptor to a principle where the seller needs to be aware of what he's selling. So, gone are the days of wanting to have fine prints and, for sellers or banks being to rely on that. So these were some of the, I think, two, insofar as I'm concerned, two very important piece of legislation. So what I would request, Mr. Gopalakrishnan, that, if you could sort of give your thoughts on, particularly from the banking sector and generally for. Yeah.
Thank you very much. As far as bank is concerned, banking sector is concerned, right from time immemorial, it was governed by RBI. See, the Banking Regulation Act, which governs it, which is the Bible as far as the banking is concerned, was enacted somewhere in 1949, and it is one of the few acts which has not gone much of a changes, except for the last time, it was in 13, there was a slight change on it. Talking about Banking Regulation Act, I have a disagreement with what the Justice Sri Krishna Committee's report is concerned in creating a super regulator. Because super regulator, what happens is, these super regulators are not effective because, so you can't be the jack of all trades. You have to be a master of something, and you have to understand before, you implement or you come out with something. Otherwise, it will be simply like the company law, which has now come into 2013 Act, which is completely in a chaos. See, many people ask. And each of the provisions, if you look at each of the provisions from my own experience, this is typically practical experience I'm saying. If you look at the Banking Regulation Act, Section 6 says what are the things which a bank can do. So normally, if you all believe, the banking means, so you deposit some money, and when you need money, you cut a check and get the money, and the bank lends it, and your money is safe in a bank. But if you look at today's banking system, it sells everything. It sells insurance, it sells health insurance, it sells gold coins, and and a day will come, when it can even sell consumer goods. See, there is nothing wrong in it. But what happens is, it is such a way it was enacted that one section says that anything which the central government may notify, which the bank can do it. And subsequently, when the enlargement of the banking system came, and when the needs of the people came, otherwise you don't have ATMs today, because see, the banking system, if you look at the real banking system, that says banks books has to be closed on each day at a particular date. At night, you can go and take money, that will come to an end. So these are all things which has happened because of the fact that the regulator is only looking at one product, he is researching only at one product, and that is the banking system, and he is accepting the global practices which are there. So banking system, the super regulator which is enacted is absolutely something which will destroy the banking system. If you look at 2006 to 8, world apart, the banks fell, in the sense, see, like the Lehman Brothers, everything happened. But what happens is in India, nothing of that sort happened. Because today, if you look at the banking system, if the bank fails, see, if the RBI is of the opinion, because RBI comes and audits every bank in a year, at least 3 months, they are in any bank, they have a separate room, they sit and, each and every one they have, and they have a, right to give directions, and they have the right to supersede the board, everything is there. So what happens is if the financials or, the balance sheet of a bank is found to be weak, then what happens is it can give a direction that it has to be merged with another bank, or it has to infuse few capital, or the weakness, the system's weakness is found out, and medicine is given to it, either you come out. And therefore I believe that none of the banks in India is going to fail, none of the large banks in India is going to fail, because RBI will use it and make it definitely merge with another banks. The consolidation which is happening. Many of the consolidation which you hear in paper may be not because it has happened because of certain deals which has happened, not the latest one, Kotak and IMG, I'm saying, but other, where, the public sector banks merge. It is because of the financial sector. The Bank of Rajasthan merged with ICICI. And, that's because of the reason. Centurion Bank merged with HDFC. The reason is, RBI's direction. It is all RBI's direction. I myself was a part and parcel of a banking system, which means, at that time I was in, that Axis Bank was called UTA Bank. They had to merge with Global Trust Bank, which is an Hyderabad-based bank. But subsequently, everything was fine. The RBI approved everything. But when it came to the crux, they found that something is missing in the Global Trust Bank. Instead, they called off the merger, and then they forced merger of that bank with OBC. I think that is what RBI is happening. So coming back to the corporate governance in banking system is concerned, Section 10 of the Banking Regulation Act, right from the very beginning, before Class 49 or 49 of the listing agreement came, or before the new act came of about independent directors and all those things, It also envisaged that, not more than 50% of the directors of the bank shall not have any connection with the promoters, and they shall have adequate knowledge in various subjects. So this is always there, See, I always believe that the concept of banking is something which is a well thought out theory. And Section 35 says that the RBI is at liberty to give any kind of direction to the banks, and which the direction has to be followed. So that's why today what happens is, if RBI gives a direction under 35, because many of the banks, you may have about 4 years back, about 18 banks were penalized by RBI for dealing with a product called derivative. Okay. So derivative product, 18 banks were penalized. The penalty was of a different nature, but nothing happened. Nobody went to the court and challenged it, because RBI's decision, as far as is concerned, that not that they can challenge it, because they know what is happening in the bank, and they are a specialized area. They are specialized, instrument. They're created to look into one particular product. So that's where it happens. The other thing which Nilanjan was saying is about the consumer forum and the other issues. The other issues are concerned, what happened is, see, consumer forum is enacted in, Consumer Protection Act was enacted in 1986. It says, over the years, judge made the laws and says that, financial services come under the purview of it. There is absolutely no doubt about it. But my only doubt about is that, people who are deciding about the banking, the deficiency in service as far as the bank is concerned, in a consumer forum is concerned, I fear that they are not well equipped to understand the banking, what is banking, and what is the transaction which is envisaged. For example, I'll tell you a very simple example. When there is a phishing attack from my account, means, say phishing attack happens, when my ID, customer ID and my password is hacked by somebody, or, he gets it, or I go into a wrong site and, there I get it, somebody gets it and, he transfers the money. So this happens. Subsequent to that, the person who has been the victim has two, options. One is to fight against the bank under the Information Technology Act, because, under Section 43 of that Act, he can go and file a petition. The other thing is that, he can write to the banking ombudsman, but banking ombudsman puts a limit, saying that, they cannot order anything which is beyond 10 lakhs of rupees. There is a limit, because it's a kind of, mediation or, alternate dispute resolution. But when you go to a consumer forum, where there is no limit or anything, I don't think that the members sitting there are experts to decide as to how a phishing attack occurred. And it becomes, see, it's like it's very difficult to make them understand how a password is protected and how it is kept in the server, how even the bank doesn't know the password of the customer. These are all things, simply say, though, this has happened, the bank is liable to pay. I'm not justifying the banks. So there are certain internal frauds which happens in the banks. Banks that's something which the bank has to compulsorily make good. That's RBI's direction, which says that, it's unwritten direction, but banks will have to make good of it. So these are issues which needs to be taken. So I think for Consumer Protection Act, even though the judgment, it's the Supreme Court has come and said that, okay, financial services fall under the facet of Consumer Protection Act. I think it is high time that we have a separate code for financial products. We have people who are manning there has to have knowledge of banking, insurance. When I'm saying about banking, because my experience is in banking, the same sentiment may be told by a person who is in insurance also, saying how can a consumer protection consumer court decide on insurance, or these are things which needs to be done. So I always believe that RBI is the best regulator in the world as far as India is or the world is concerned, and that is why the banking system doesn't fail. Sometimes I also have felt very, very, very sad about certain stand which they have taken, because they are very rigid. They don't open up. You go and ask them anything informally, they won't answer. They will say, you whatever it is, you put it in writing, we will answer. So their regulations comes, and sometimes the regulations may be very harsh. And today, when I'm coming, I read the speech of the governor regarding how the banks have been hiding the NPA, how they are dressing up the balance sheet, and he says that this is something which banks has to focus more on recovery, because since Shashank is going to deal with the recovery, I'm not going to touch on this. Yes, that's something which has to be there. But if you look at it, what is the root cause of such NPAs? That is something which needs to be investigated. I won't say that all NPAs as a result of the climatic conditions or the change in scenario or the business conditions or a thing. But monitoring is something which is absent. When I give a huge amount of money to somebody, and banks doesn't have a system to monitor as to whether the money goes directly for this purpose for which it is borrowed. This is something which the banks always fail, because bank has a limitation for that. That is something which somebody has to look into it. Banks now, RBI has come out very heavily on banks and saying that monitoring has to be done. So whether the other bigger question which we all has to think is that whether evergreening or restructuring the loans is something which is to be taken as a general rule, or in very exceptional cases which we have to take. And when I come to before I touch upon the before I give it the mic to Shashank, one thing I want to say is that even though there is a DRT, even though there is SURFACI, and as Nilanjan said, SURFACI is enacted saying that without the intervention of the court I can take over a secured asset and sell it. But the fact of the matter is that at every point courts interferes, rightly or wrongly. So the purpose for which the act is enacted has gone astray. So there is something which we have to do, is to enact some law like the bankruptcy chapter 11 of USA or something of that sort, which has to be applicable to a set of people or the corporates, wherein you have to put the fear into their mind, whether who has borrowed, that if I don't pay, that's the end of my this thing. Today, Kingfisher, it's borrowing, I mean, it's NPA everywhere, but courts have been granting stay and saying that you cannot be declared as a willful defaulter. So these are issues which needs to be tackled, and for a DRT has to be established, saying that every 6 months you have to, within 6 months, the DRT has to settle any case, but it never happens. It takes a minimum of 2 to 3 years for a court, and certain parts of the country, like eastern part, it takes more than that. So these are issues which needs to be looked upon to it.
Thank you for that. Just one comment I wanted to do before I sort of request Shashank for his comments on the